All right, so if you're a creator, you know that fear, right? The one where you see your hard work copied. So, how do you actually protect yourself? Well, here in the EU, you've got two main toolkits in your legal arsenal. And today, we're going to dive into exactly how, and maybe more importantly, when you should be using them.
You know the feeling. You're walking through a high street shop and you spot it. A piece of furniture that looks suspiciously familiar, like a dead ringer for a famous, super high-end design. And you can't help but wonder, wait, is that legal? Where exactly does the law draw that line between, being inspired by something and just straight up ripping it off? It's a huge question, a multi-billion-dollar question that the courts are wrestling with all the time.
Okay, let's get specific with a real world example. On one side, you have the designer Palais Royale table, and on the other, the retail cord table. I mean, the similarity is just undeniable, right? So put yourself in the shoes of the original designer for a second. What do you do? Well, in the EU, you've got two main legal paths you can go down. You've got design rights and you've got copyright. And trust me, they have very different goals. Knowing which one to use is absolutely critical. All right, let's dive into that first toolkit, design rights. This one is all about protecting the appearance of a product, its look. And a recent case involving deity shoes is the perfect way to see how this actually works in practice. So, what does it actually take to get one of these design rights? You might be surprised, it's actually pretty straightforward. The law really only lays out two main requirements. First, the design has to be new, and that just means no identical design has ever been made public before. And second, it has to have individual character. Okay, and this is where it gets really interesting. That whole individual character thing, it's judged by a pretty simple test. The big question is, does the design create a different overall impression on what's called an informed user when you compare it to anything that came before? And it's not about the blood, sweat, and tears that went into making it. It's all about how it looks to someone who, knows their stuff in that particular field.
Now, check this out, because what's really fascinating here is what isn't required. The courts have made it super clear. A design doesn't have to be the result of some massive intellectual effort or genuine design activity. And that is a really big deal. It means that even simple tweaks, like customizing parts you picked from a catalog, can be protected, just as long as that final look is new and gives off that different overall impression. So, what does all this mean for a designer's creative freedom? Well, the courts say your freedom is only limited by things you literally can't get around, like the technical function of an item. I mean, a shoe has to fit a foot, right? Or, other legal requirements. But what about following a fashion trend? Nope. The court says that's a choice you make, not a constraint you're stuck with. And for an industry like fashion that moves at lightning speed, this clarification is absolutely massive.
Okay, time for our second toolkit. And this one, this one steps it up a notch, offering much stronger and way longer lasting protection. We're talking about copyright. And with copyright, we're not just talking about the look anymore. This is about protecting the creation itself, the thing as a work of applied art. And this idea has been right at the center of some big, high-profile legal battles over furniture designs, like the ones involving Mio and USM Haller. Right off the bat, you need to know the bar for copyright is definitely higher. It's not there to protect just any old appearance. It protects a work. And for something to be considered a work that gets copyright protection, it has to be original. So what does that mean? It means it has to be the creator's very own intellectual creation, something that really reflects their free and creative choices. It's what the law beautifully calls their personal touch. And honestly, what I think is so cool about this is how simple and, fair the copyright test is. It's the exact same test for a painting as it is for a chair. Just because a chair has a job to do, being a chair, doesn't mean it has to jump over some higher creative hurdle. And this is so important, the law doesn't pretend to be an art critic. It could not care less if a design has artistic value. The only thing that matters is, did this thing come from the creator's own free creative choices? That's it.
Okay, so we've got these two really powerful but also really different toolkits, right? Let's do a little head-to-head comparison and really see how they stack up against each other.
Yeah, when you lay it all out like this, the differences are just stark. You've got design right, which protects a look and doesn't demand a huge creative effort. Then you have copyright, which protects the work itself, and it has to be rooted in that author's personal touch. But honestly, the real jaw-dropper is the duration. A design right, it maxes out at 25 years. Copyright, we're talking the entire life of the creator, plus another 70 years after that. I mean, that is just a staggering difference.
So let's bring this all back down to earth. What does all this legal theory actually mean for the creators, the designers, the entrepreneurs out there working today? Why should you care about any of this?
Well, it means you actually have two clear paths to protect your investment. And here's the key. You can, and often should, use both. Think of it like this. Step 1, you can lock down the look of your product with a design right. The bar is lower, it's easier to get. But then, for step 2, if your design really is the result of your own free and creative choices, it can also be protected by copyright. And that gives you that incredibly powerful long-term security. So yeah, getting this double protection is absolutely possible. And please, don't think of this as some kind of either-or choice you have to make. The EU's highest court has been crystal clear about this. They basically said, look, these two systems are designed for fundamentally different jobs. They're meant to exist side by side, giving you these valuable layers of protection for all your creative work.
I mean, just to put it in the starkest terms possible, think about that time difference again. For the very same product, copyright protection can last, get this, more than 45 years longer than the absolute maximum you can get from a design right. For anyone trying to build a lasting brand, a real legacy, that's a total game changer. So, what's the bottom line here? It's that these legal rulings aren't just some dusty academic exercises. They give creators a much, much clearer roadmap for how to protect their work. And let's be real, in an economy where knockoffs and copycats are everywhere you look, that kind of clarity is absolutely essential for protecting both your creative and your financial investments. And that really brings us to a final big thought to leave you with. These cases do a great job of clearing up the rules for today, but as we rocket into a future that's dominated by the crazy fast cycles of fast fashion and the rise of AI-generated designs, the central question really becomes, what does originality, what does that personal touch even mean anymore? And that's a question that designers and the law are going to be grappling with for a long, long time.